Hi, this is Josh Blackman, and I'm happy to announce the fourth match in the Harlan Institute Virtual Supreme Court competition. Today, we have a team from Westchester, Pennsylvania, Alex Chen and Forum Shah, and we have a team from Greenwich, Connecticut, Arjun Kishore and Nicole Orlowski. And they'll be arguing the case of New York State Rifle and Pistol Club versus Bruin. Petitioners, are you ready? Okay. And you may begin whenever you're ready.
Mr. Chief Justice, and may it please the court. In 2014 and 2008, respectively, petitioners Mr. Nash and Mr. Koch applied for public handgun licenses from the Rensselaer County Licensing Officer, defendant Mr. McNally, as per New York law. Both were granted licenses within 6 months that restricted their firearm carrying to hunting and target only. Thus, neither was granted the ability to carry a firearm in public for self-defense. In 2016 and 2017, respectively, petitioners applied again to remove these restrictions. Both petitioners had all qualifications, no convictions, and firearm training. Their appeal was denied and the restrictions remained for supposed lack of proper cause, needed to differentiate their circumstances from the broader New York public. Although Mr. Nash had cited a string of robberies in his neighborhood, this was not atypical enough of a need to warrant a public self-defense carrying license. Neither are able to exercise this right for this reason today. The New York State Rifle and Pistol Association joins suit.
New York State's denial of petitioners' applications for concealed carry licenses for self-defense flagrantly violates the Second Amendment of the Constitution. The use of the two verbs to keep and to bear in the plain text of the amendment are reflective of the great care the founders took in framing the Constitution. Using the historical meaning of these verbs, their use, and the notion that, quote, it cannot be presumed that any clause in the Constitution is intended to be without effect, end quote, from Marbury v. Madison, it is clear that there's a stark distinction between them. To keep means to maintain arms in the home, and to bear means to carry them outside of the home.
Thank you, Counselor. So let's start with Heller. What did Heller actually decide about the Second Amendment outside the home? What was actually decided in that case? Either one, whoever wants to answer.
Oh, yeah. So the Heller holdings essentially established an individual right to keep arms within the home. It struck down the trigger lock requirement that DC's code had enforced.
And did Heller actually say anything about the right outside the home?
Your Honor, I do not believe that there was an explicit focus on the right to carry outside the home. Although I do think that the court held that to keep and to bear arms were protected under the Second Amendment as individual rights.
So you said nothing explicit. Was there something that perhaps was implicit or short of an explicit holding?
Well, the second part of our argument, we believe that the rationale in Heller also implied or should be expanded to the fact that petitioners should have the right to bear arms in public.
Elaborating on that, we believe that because they're both in the operative clause of the Second Amendment. So if one rationale is applied to keep, then the same rationale should logically be applied to bear.
Okay, Counselor Ms. Shah, I can ask you a question. What do you think is the relevant standard of review for Second Amendment claims?
The relevant standard of review here, Your Honor, would be strict scrutiny because a fundamental constitutional right is being violated.
Why are you getting to strict scrutiny instead of intermediate?
Yes, Your Honor, we must use strict scrutiny because the right to self-defense is a fundamental core Bill of Rights amendment, that it's a right protected, and that's a fundamental right. So we must use strict scrutiny.
Didn't Heller say heightened scrutiny?
The holding in Heller does not, which was presumptively lawful, does not exclude the usage of strict scrutiny as the appropriate standard of review.
Right, it doesn't exclude strict scrutiny, but it likewise doesn't expressly include strict scrutiny. So I guess I'm not understanding fully how you just automatically go straight to strict because it's a fundamental right.
Your Honor, we believe that since typically strict scrutiny is applied when a Bill of Rights amendment excludes necessarily a large class of or protected class of citizens. In this case, the New York proper cause law is excluding a supermajority of New York residents who have perfectly valid reasons for wanting self-defense. Mr. Nash cited a string of robberies in his neighborhood. The proper clause essentially excludes all of these members of society from exercising their Second Amendment rights. And we believe that this exclusion, this barring of a whole class of citizens who have perfectly law-abiding terms of bearing arms, constitutes the application of strict scrutiny as it is the fundamental right.
Counselor, if I could interrupt for a second. Let's say you're right about strict scrutiny. Does that mean that all Second Amendment claims are governed by strict scrutiny?
Well,
Your Honor, if it goes to the core of the Second Amendment, which is the right to self-defense, then yes, strict scrutiny must be used because
But
that's
what about felons? What if I'm a convicted murderer and I lay out of jail? Can I get a gun? Is that a strict scrutiny?
No, Your
No,
Honor,
because
because
the holdings in
Yeah, it's fine. Yes, good.
the holdings in Heller established that there were some presumptively lawful gun regulations, and such as sensitive places and convicted felons. So
Okay.
we would not use strict scrutiny.
And Mr. Shen, you can jump in. I know it's hard with Zoom to go
Yeah.
1 and 2, so you
Sorry
guys can
about
take
that.
turns. It's we understand how that goes. Okay.
So typically, when we find that Heller upheld the notion that the average law-abiding citizen should have the right to bear arms, excluding areas such as sensitive places, and obviously the Heller decision still upheld many aspects of presumptively lawful regulations.
Well, let me ask you something, Counselor. What is a sensitive place?
A sensitive place would include like a school or a government building in which bearing arms would be dangerous to public safety.
Could a whole city be a sensitive place?
We don't find that a whole city would be, because there is obviously a need for self-defense in
What about a
many
subway? What about the subway in New York?
We would also not necessarily find that to be a place of
But there's crime. People get robbed in the subway. They get
yeah,
mugged,
yeah.
they
So
get raped in the subway.
we would not find that a place where sensitive, Your Honor, where sensitive.
So you would allow concealed carry inside of a subway?
Yes, Your Honor, because these licenses are concealed carry licenses for self-defense, not for the intimidation of others.
What about in Yankee Stadium, where 60,000 people are watching a baseball game?
In this case, typically we would not allow firearms within this. It's like in a
Why
museum
yes for the
or
subway, but no for the Yankee Stadium? Why is this subway okay, but not Yankee Stadium?
because a subway is a form of public transportation here where crime is a lot more likely to.
Okay, then in a state park. Would state park be allowed to carry? Public park?
We still reserve the right for legislatures to
Well, then
Produce
maybe a
legislation
question
that-
for Ms. Shaw, if I can.
Yes.
I
Your Honor.
agree, there are difficult line drawing issues, right? We all agree. Shouldn't the legislature be drawing these lines? Why is the court? Why are you asking these unelected judges to draw these lines when really maybe it should be the legislature drawing these lines?
Your Honor, because the 14th Amendment in the Due Process Clause says that the Second Amendment, and as all of the Bill of Rights Amendment, apply to states as well. So this state is flagrantly violating the Second Amendment. So we must intervene and.
But how are judges supposed to know better, Ms. Shaw? How? Who decides? Why are we the ones that decide?
Your Honor, by striking down the proper cause law, the judges would be paving the way for more narrowly tailored options to solve the issue of public safety with handgun crime. The proper cause law does not adequately address this issue, and that is why the judges must strike it down.
All right, you may continue.
All right.
In the Heller decision, this court found that the Second Amendment protects an individual right to keep arms within the home, regardless of militia membership. DC's law in that case.
In your brief, you state that your arguments
Oh, I'm
don't
sorry.
create an
I'm sorry.
unqualified.
Something that's I'm sorry. A video start playing my computer. I'm so sorry about that. Go ahead.
Are you able to hear me?
Oh, actually, go ahead. Yes, go ahead.
Oh, yes. So in your brief, counsel, you state that your arguments don't create an unqualified entitlement to carry arms outside the home, but rather only removes unconstitutional requirements. What requirements would you suggest should be in place to be approved for a concealed carry license?
Yes, Your Honor. Background checks, for example, would be a gun regulation that is narrowly tailored to the cause. similar regulations might be on the ammunition industry, and these would help make sure that an unrestricted right is not created.
Yeah, to elaborate on that, we still, a ruling in favor of petitioners would still leave in place many of the aspects of presumptively lawful regulations that are there to ensure that the public is still safe. For example, there's no reason for the average person to have a gun on a school campus. What petitioners ask for here is to remove the concealed carry license restrictions that bar the vast majority of New York citizens from owning a gun when there really should not be.
Okay, Council, you have time. Okay, thank you so much.
Thank you.
Petitioners, please turn on your cameras and you'll have, respondents, turn your cameras, you'll have 15 minutes. Whenever you're ready to begin.
Chief Justice, and may it please the court. In September 2014, as mentioned, the two petitioners applied for concealed carry permits. They were allowed for hunting and target practice, as well as keeping guns in off-road and backcountry and to and from work. See footnote 13. They appealed these decisions, which were later upheld. The question at play today is whether the New York law proper cause requirement should be upheld as constitutional. We'll first start with a review standard, which we believe should be intermediate scrutiny, and then outline the three arguments why this proper cause should be upheld as constitutional.
We believe that the standard of intermediate scrutiny should be applied in this case because DC versus Heller explicitly gives examples of presumptively unlawful situations, and the paradox of presumptively lawful and presumptively unlawful places this case outside of the realm of strict scrutiny. For example, a felon is not able to own a gun permit. This was established in many laws, especially, and this means that the paradox of presumptively lawful does not stand here. If you can find even one circumstances, such as the felons, where it is presumptively unlawful, the standard of strict scrutiny for this case no longer holds. Now, to move into our system of federalism and the reason why New York State is able to put this law into place, we've seen that the state's rights as established in the 10th Amendment are incredibly important in allowing the state to create laws that are best for their citizens. We can see this in the New York State law, and we can see this throughout history. For example, in the late 17th century, New Hampshire, New Jersey, and Massachusetts all placed restrictions on bearing arms and breaching the peace, as seen in our 25th and 26th footnotes. There's no one-size-fits-all approach to legislating about the Second Amendment, and it's important to give the state's discretion in legislating about gun laws in a way that is still mindful of the Constitution. I'll now pass it off to my co-counselor to speak about.
Or you can pass it off to me. So I think you've hit on a couple of good points that we discussed before. Heller did say you could disarm felons, and presumptively that means it's not strict scrutiny. But your friend, the other side said, well, what's the core of the right? Right, the core of the right is the right to bear arms. Is felons having a gun part of the core of the Second Amendment?
Felons having a gun is not part of the core of the Second Amendment. However, it demonstrates that you can't have a presumptively lawful standard of strict scrutiny across the board. We look at the right to bear arms as a fundamental right, but in entering into a society, you give up some of those rights. And in this case, felons do not have that right.
Do you want to lock yourself into that position?
Well, if I could add, we believe that the fundamental question about who gets the right to bear arms is not whether someone is a felon or not, but it's based on self-defense, as established in Heller. It's based on self-defense. So the question about felons bans being presumptively lawful is that felons, might have violent tendencies and might harm the public with them.
Let's put aside felons for a bit, right? Heller said that you can ban guns in sensitive places, right? Schools, government buildings, etc. But doesn't saying that there are sensitive places imply that some places are not sensitive? Right? In other words, aren't there going to be some non-sensitive places?
That's correct. There are some non-sensitive places. However, one thing I do want to highlight, Your Honor.
Well, what are those non-sensitive places? I know you answer the question very well. What are those non-sensitive places?
The general public, for example, walking down the street generally does not apply as a sensitive place.
So can I carry a gun down the street of Manhattan? Do I have a right to carry there?
Well, no, Your Honor, and that was getting to the second element of my response, which is that it's not binary whether a place is sensitive or not. In this specific case we saw, for example, bearing a gun, for example, in rural New York, where there's practically no people around, and you're at a much greater risk because you don't have police around you, and you're less likely to get in incidents which might cause you to discharge your arm at people who are innocent. For example, in rural areas, as I mentioned, that is far less sensitive than the general public. For example,
Does New York have a different standard for upstate New York and the sort of rural areas with the petitioners? Because I think the petitioners from Rensselaer County, which is a fairly, not a very crowded area.
Well, Your Honor, we would establish that New York does not have a different standard of review for public concealed carry applications based on the location in the state, but they take into account the need for self-defense is based somewhat on the location.
Right.
Well. I'm sorry, Justice Carrillo, go ahead. I'm sorry.
My understanding of the law is that it needs to be a specific threat, does it not? Not just that, they live in a crowded city and therefore it's more dangerous. Those people would be not denied their Second Amendment right. But if you have a specific threat of violence, if someone has been threatening you, someone sent you a note, you have an abusive ex-boyfriend, only then, after a magistrate determines you can carry a gun, can you carry a gun? Or am I misinterpreting how the law works here?
We believe that to some extent you are misinterpreting how the law works in this specific instance. For example, Nash and Koch were both granted the right to keep and bear arms in rural areas. And this
on what grounds, though? On the grounds that they lived in the country?
Exactly. And on the grounds that it'd be more difficult to have intervention and protection from law enforcement. And that exactly gets back to Honor Justice Blackmun's question about there's no explicit difference between rural and urban communities, but that's exactly our point, giving discretion to these magistrates, to these officials who are more intelligent and who can look at the precise instances in which the gun bearer is under, grants them that sort of discretion, which is better for gun rights. And that exactly ties back into our argument about federalism. The founders realized this idea exactly, that the federal government was less qualified to understand gun regulations and was more of a threat to the citizenry than the states were. This was the precise
how are these people who decide who gets the Second Amendment rights in New York appointed to their position? Are they elected? Does the governor appoint them? How does that work?
So the officers are bureaucratic appointees, and there's an appeal system for this as well. In this specific case, it was appealed to Justice McNally, I believe, who is a Supreme Court justice. So these are qualified individuals. And as I said, there's an extensive appeal process. All decisions have to be logged and sent to the citizens individually. So every single part of the decision making is able to be viewed and able to be appealed, and there is accountability within the system. To tie back into this argument about federalism, the Bill of Rights specifically applies only to the federal government. As we highlight, or rather when it was written. Sorry, apologies, Your Honor.
Again.
When the Bill of Rights was written.
Thank you, Judge.
Of course, in McDonald, it was later incorporated. Now, the reason that this is relevant is because it shows the founders' intention to give the states discretion over regulating guns, because they can have more tailored and more limited, basically, regulations. New York can regulate for New York, which is a much smaller area than the federal government regulating for the entirety of the United States. Now, for our next argument about the expectation of safety, which I'll hand off to my partner.
So when we look at the expectation of safety, we first look at policing, and the way to evaluate the relation between guns and crime is in scholarly journals and in the political process, rather than the invocation of ambiguous texts that long precede the contemporary debate. And this is from Frank Easterrick's opinion on the district court case NRA.
Right. So counsel, if I can, in Heller, there were lots of briefs that said guns are bad, guns are dangerous. And the court said, okay, that's nice. We're going to rule against this district anyway. Why should we care what all these very smart scientists think? The law is the law. If you don't like the law, change it.
Well, Your Honor, when we look at the law, we look at the goal of the government in creating a safe country for everyone, and the fact that we enter into a society and we leave a state of nature in order to have that protection by the government. So in protecting the fundamental right to bear arms, we need to also keep in mind that guns present in certain cases a danger to safety. And this is a direct contradiction into the reason we would enter into a society.
why do we need the good cause standard though? I think we all agree, at least I think your friends on the side agree, that background checks are okay, right? So what if New York runs background checks? They require a gun safety course, right? You have to take training, you have to show proficiency in accuracy, target practice, etc. Why isn't that enough? Why can't we trust people who are going through all the various safety training that they won't discharge the gun in unsafe fashion?
Well, the reason it's not not enough, Your Honor, is because situations can change. As you said, with sensitive places, you could have well-trained individuals. There's precedent for this. You know, someone who's gone through gun courses and is well-trained still isn't allowed to bring a gun into Yankee Stadium because of that exact safety threat. And to tie back into this idea of safety, since the Second Amendment is based on it, there's actually precedent at looking at the history and the impact at gun laws. For example, in New York, there's been a recent increase in gun crimes, New York City rather, there's been an increase in gun homicides, which would be a good reason for New York to look at.
But do those people who are inflicting gun violence have concealed carry permits?
Not in all situations, but as we mentioned in our brief in one of the studies, there is a correlation in certain situations between increased gun ownership, specifically concealed and open carry, and gun violence. And it's exactly for that reason. We see in the case Gold v. Maryland, which is footnote number 36, that the court has a history at looking at empirical data to fulfill scrutiny standards for the Second Amendment, which is to say, if open carry is permitted in a certain area and that drastically increases the gun violence, then the legislators can restrict.
Counselor, if I may, what case specifically did we look at empirical data?
That was the case Gold v. Morgan. It's footnote number 36 in our brief, and it was.
And what did that case deal with?
That was a case about gun regulations, and I don't recall specifically what the regulation was, but it essentially the courts permitted the use of empirical data.
And that was a Supreme Court case?
No, it was not. It was an appellate court case.
Okay.
All right, you can proceed, Counselor.
To tie back into our argument about the expectation for safety, as we've mentioned, Heller establishes that safety is based off of self-defense. And as we have established, Heller also shows that the danger that guns pose to the people around them change as well. So with policing, with urbanization and all of the developments that in our society, it's clear that the requirement for self-defense in certain locations decreases. And for this reason,
so while we are just talking about statistics, while the majority of the other states do allow people to carry firearms outside of their home, why shouldn't New York join the majority of those states?
Your Honor, we believe that it's at the discretion of New York whether or not they'd like to join those states, because this is a state law and because the system of federalism allows them to legislate in a way that fits the needs of their citizens and their specific structure within their state. What works for Montana or Wyoming or California may not work for New York, and that's why we believe New York has the ability to legislate.
Yeah, but was it?
Go ahead, Professor. You go first.
I said, well, wasn't that the same reasoning the South used to uphold segregation? What's right for Mississippi and Alabama isn't necessarily right for what New York was. I mean, that sounds like you're going down the same line there.
Well, Your Honor, we feel that segregation is quite a different circumstance, given that it was obviously in many Supreme Court cases proved to be a violation of the 14th Amendment rather, my apologies.
Right, and this could very well be a violation of the Second Amendment, could it not?
We do not believe that this is a violation of the Second Amendment, Your Honor, because we believe that the Second Amendment right to keep and bear arms is still protected within certain regulations and realms, and it is allowing citizens to use guns if they demonstrate a proper cause, which is well within the realm of constitutionality.
Let me. I think my question is similar to Justice Carrillo's, and also Justice Wollaston's question. Do we usually allow constitutional rights to vary by location? Like a Miranda warning, right? Do you give one Miranda warning in Texas and different Miranda warning in New York and different Miranda warning in California? I thought perhaps different languages for sure, but like the content of constitutional rights usually doesn't vary by state.
Well, Your Honor, usually it doesn't. However, there are exceptions. For example, the First Amendment right, which generally people would regard as fundamental to free speech, parade permits, for example, would vary. There's often discretion afforded to states as to who gets parade permits based on, for example, how urban an area is, the surrounding environment, how loud you'll be. So while it's not common for constitutional rights to be based on location, there is precedent for it to be based on location and not solely just for the Second.
So the clients in this case, petitioners, I think, are from upstate New York. What if we said you can have your gun? It's upstate New York. We can't go to Manhattan. You can't go to New York City. Would that be okay?
Well, Your Honor, the reason that it's different here is because the petitioners are moving around. It shouldn't be based solely off where the petitioners live. As we mentioned, they do have the Second Amendment right, and they are able to have their gun on them when they're in those rural areas, when they're driving to and from work. But when they get into that more urban area, when they get around a ton of people, and when the situation gets more and more tense, then that was felt to be restricted. That there's a better reason to restrict it, because the expectation for safety because of law enforcement increases, and the threat that that gun poses to the public also increases. So for those two reasons, there's a decreased need for self-defense for those petitioners, and therefore they are not able rather to bear their arm.
You have about 30 seconds left, Counselor, if you want to wrap up.
Yes, Your Honor. So for these reasons, we believe that the court should side with the respondents and should apply the standard of intermediate scrutiny in reviewing this case in order to ensure that New York State and other states like it can continue the system of federalism, create laws that are well within the realm of Second Amendment constitutional rules, and make sure that we are still validating citizens' constitutional rights. Thank you.
Okay, excellent. Thank you so much to the respondents. If the petitioners can please come back on camera, and you have 5 minutes rebuttal time. Whenever you're ready, begin.
This court should apply strict scrutiny. We find that while the government has a vested interest, this law is not narrowly tailored to the purpose of public safety. Instead, it hurts an entire class of law-abiding citizens who cannot exercise their right to self-defense because of this unconstitutional law. This fundamental right is not to be given or taken away based on the circumstance or at the discretion of a government official's interpretation. The respondents claim that the proper cause law is vital to public safety and that without it, a lack of order will follow. As explained earlier, this is simply not the case. It is clear again that a ruling in the petitioner's favor does not work to weaken the longstanding and presumptively lawful regulations discussed previously. At the same time, the proper cause law infringes upon the law-abiding citizen's right to carry firearms for self-defense and peace of mind when there is a perceived threat or concern for an individual's safety.
All right, so Counselor, let me sort of just go back to the question we were asking before. Would your clients be okay with a permit to carry perhaps everywhere in New York, except for New York City, the 5 boroughs of New York? You can carry everywhere in New York but New York City, right? The other parts, carry wherever you want, but just not in the city.
Well, we do
Would you
not
be okay with
believe
that?
that. Yes, Your Honor, we don't believe that we should be, applying the licenses based on whether it's an urban or rural area. We apply it based on whether there's a perceived or a great increased threat of there being a gun on that certain campus. For example, walking down some of the streets of New York with a self-defense concealed carry license would be perfectly constitutional, as there is a perceived threat of possible robberies or muggings. However, bringing this firearm into the state Supreme Court or the Southern District of New York District Federal Court Circuit in Manhattan would definitely not constitute.
Why couldn't New York just designate New York City, which is a very dense area? It's basically like Yankee Stadium times a million, right? Why can't the entire 5 boroughs of New York, maybe exclude Staten Island, but the other 4 boroughs, why couldn't you make them all sensitive places?
Well, you have to, Your Honor, we have to establish that the fact that there is still a perceived threat of the possible need for self-defense in these areas. Walking down some neighborhoods in New York would be very ill-advised without some form of self-defense. However, you could designate parts of New York as sensitive places, as the need for self-defense there would be greatly decreased.
But Ms. Shaw, isn't the fact that we have to sort of make really tough judgment calls about what is sensitive, what's not, isn't that good enough reason for us to simply affirm and not go into this case and leave this for the elected branches to handle?
Your Honor, we do need to go into this case because the proper cause law does not, it simply restricts the right for all law-abiding citizens, where some may have a need for self-defense. The proper cause law requires this atypical need, which is a standard that is unconstitutional. While there are sensitive places are to protect public safety, however, the proper cause law is not protecting, was not adequately addressing the concern of public safety. Therefore, we must address this in court.
If I could
Maybe
elaborate.
one more question if I can. What's the strongest piece of historical evidence you have in support of your position?
Well, the founders definitely interpreted that this need for self-defense in carrying at the time of the founding. In fact, Tench Cox, who was a great interpreter directly after the drafting of the Second Amendment, he interpreted the Second Amendment as to include a great need for self-defense. And in fact, this interpretation was so well applauded by the original founders. Madison even wrote a letter to him supporting this notion that self-defense is a huge part of the Second Amendment. In addition, they understood that this carrying outside of the home to be exactly that. The bearing arms was carrying outside the home. In the game bill drafted by Madison and Jefferson, they understood that bearing arms for self-defense is something as bearing as something that a deer hunter would do.
And the strongest piece of evidence that we have is that many state constitutions were written following the writing of the Constitution. And in these state constitutions, the right to self-defense was explicitly written. For example, Article 13 in the Pennsylvania State Constitution stated that the people have a right to bear arms for the defense of themselves. Therefore, we know that the right to bear arms was commonly understood at that time to be directly related to the fundamental right of self-defense.
Okay, right on time. Thank you so much. Wow, that was excellent. If the other team, I'm sorry, turned your cameras off very rudely. You can turn your cameras back on, and Aaron too. Yeah, I don't like everything on the screen. It gets distracting.
It says we can turn our videos on because.
Oh, I blocked you. Okay, let me unblock you. I'm sorry. I'm sorry about that. Ask to start video. There you go. Welcome back to the club. Yeah, no, I don't want to have on the screen at the same time. That was really good. I think that was one of our best rounds today. That was really good. What I loved, not just liked, what I loved about both teams is when I asked you a hard question, your answer was yes, however, or no, but. That is the best way of answering a question. Don't give me maybe, right? Reed and Ashley, don't give me maybe. That's the worst. Give me a yes, but, or a no, however, and immediately pivot from your strength, from your weakness to your strength. I was pushing you on lines and you conceded, okay, no subway, right? No Yankee Stadium. You could, yeah, sure, carry on the subway, go in Yankee Stadium, but you didn't concede that, but you're willing to take that line. But then when I said all of New York City, you didn't take that line, right? This was a strong round because you did it. Also, I think both of you interacted from left to right, from number 1 to number 2 smoothly. I know it's hard in Zoom. And I know you're all in the same place. I hope at some point for future rounds, maybe you can be together. Maybe, one can hope in the world of Zoom. But even though you're not in the same physical location, you were able to sort of transition from one to the other very strongly. That could have been a round in a law school tournament. No question. You could walk into a law school tomorrow and do a round, and you would probably advance. That was fantastic. Ashley and Reed, do you have some thoughts you want to share with the students?
So y'all were just really good advocates. I mean, you clearly came really well prepared and just wanted to argue your side. And either way, I know maybe 2 questions got hit with y'all at once, and I really liked how y'all would answer one and then go back to the other, because it's really important, not to leave a question unanswered. And I think y'all did a really good job at that.
Yeah, I think what was really strong this round for both teams was how you answered the questions. Like Professor Blackman said, the yes and the no. And then what I noticed also is what we call, and when I do moot court, is the rephrasing. When I asked, am I misinterpreting the law? You spit it back to me. Yes, you are misinterpreting the law because, and both of y'all did that for both mine and Professor Blackman's questions. Both teams did that very well. I'm very impressed. One thing that I will note though, and it's hard over Zoom. Try your best not to speak over the panel, and it gets really difficult because of the whole Zoom thing. But if you see the little yellow box pop up, just stop. But other than that, great job.
That's awesome. I always give an opportunity if you want to ask us questions, Mr. Hall or any of the students. Please feel free to grill us, because we've been asking you very difficult questions for the last 40 minutes. What do you think? Anything? Aaron, just put your hand down. See if the kids have questions first. I've known this guy for years. We go way back. No questions? No. Okay. All right, Aaron, you can ask your question.
Just wondering to what extent you find veracity in going back to Hobbesian and Lockean conceptions of the social contract and
Yeah.
the idea of curtailing rights, because the idea here, and one of the arguments, and the other team can hear this, the idea of deputizing everyone and kind of de-emphasizing the nature of trained police forces is what this potentially goes towards. We were talking about a possible line of bringing in the state of nature, and the idea of war of every man on every man if you pull back these rights. And I'm curious, I know we're in the middle of the competition, but I'm curious what your initial reaction to going back to Hobbesian and Lockean state of nature, social contract, and going that fundamental. Is that
I
too far?
don't know if you caught it, but I think I said, I don't want to lock you in on that.
I did catch that.
I was making a pun on John Locke. I hope you guys caught that. Look, I think the common law sources are all fair game. And this right of self-defense definitely goes back to Blackstone. It goes back to John Locke. I think it's absolutely fair game. So yeah, definitely. Alex, I think you had a question too. I didn't mean to cut you off.
Yeah, no problem. I was just wondering what inspired you to make this competition, because it's unheard of to ask high schoolers to write a brief from scratch with no legal experience. I mean, I just thought that was so intriguing.
Yeah, you did it, didn't you?
I mean, we
You
all
did it. I'm happy to answer the question. I graduated law school in 2009. I think most of you were like in diapers, basically. Most slightly exaggerating. I used to be young, but not anymore. And I launched a Supreme Court fantasy league. Right, it was a league where people could make predictions about the Supreme Court. And what I found was that teams of high school kids were actually playing. I didn't even know. And I got these random emails from high school teachers saying, we're using your game to teach our kids about the Supreme Court. I was like, wow, that's cool. And then I had just an epiphany one day that this would be a really useful experience to give high school students a law school experience. And initially, I just had students making predictions about cases. And then I added a component where students write blog posts about cases, get badges, like gamification. And then I actually started having students write briefs. And then we started doing oral argument over Google Hangouts. I think Aaron was one of my first teachers. I started this in 2011 or 12. So now we're, I guess, my 10th year. And why do I do it? Well, my job is a teacher. Aaron's a teacher, I'm a teacher. My job is to teach. And I have two of my favorite students sitting up on the corners of the Zoom screen right now. I love teaching. I love sharing knowledge with our society, because I firmly believe if our next generation doesn't understand our laws, we're screwed. Right? You can have all the wonderful, constitution written on paper you want, and unless people understand it, we are in trouble. And not just understand it, but be able to debate it in a civil fashion. Look, you're talking about gun control. My goodness, this is a hot button issue, and you're sitting here arguing in a very calm, collected manner, right? You're not going off the rails on, guns, and they're going to take our guns, and you guys, you're all calm, and it brings me such joy and relief to see the four of you young people make these arguments. So that's why I do it. I absolutely love it. And then Reed and Ashley are my students, and they're in law school, and they're giving up their weekend to do this also. I'm grateful for that, but they're here all day tomorrow, because we believe in this cause. We believe it's very important. And long answer to your question, but that's the answer. Yeah, Aaron, go ahead. You don't have to raise your hand.
Reed and Ashley, are you getting extra credit? I have to know.
No, that's
Good.
He has a
Thank
strict
you.
policy against that.
I'm gonna buy them lunch. That's the they'll get lunch out of it, but that's the most I can do.
That's great. Thank you. This is a commitment on your part. So, and I know studying for law school is not an easy thing. So thank you.
And Nicole, did you have a question? I see your hand kind of went up.
I believe Arjun had one first. So
Arjun, go ahead. Arjun and Nicole, whoever you want to do it.
Yeah, I did. Well, first, of course, thank you so much for running this. I really have enjoyed it, and hopefully we'll get to enjoy it a bit more. But I had a question that both applies to this case and sort of generally. So I guess either part of it. So more specific to this case, my question is about originalism versus like modern day. So with this case, we talk about like guns, and of course guns have advanced way further than the founders ever saw. So how exactly do you like personally or professionally sort of think like to balance the original text and the original beliefs of the founders with sort of technological innovations? And of course that applies to a whole multitude of issues, but
Yeah, sure. And it's not limited to guns. I mean, the framers didn't understand cell phones, right? They didn't understand the metaverse, right? They didn't know what a global positioning system is, a GPS, for a tracking device in your car. There are lots of issues that were simply not fathomable. So one idea is what weapons are in common use today, and that might be a way to define the types of guns that are provided. Other people say, well, if the framers didn't see it, that's the end of the road. If you have a right to a musket, and I think Justice Breyer said that in the case. Oh, you can have a musket in your house. Okay, wonderful. Yeah, you can have a flintlock musket. But it's a very good question. If you want reading materials on the Second Amendment, I'm happy to give you stuff. The briefs in this case were excellent. They give you all those answers, but it's not an obvious question how to answer those questions, but you're asking it. And
Actually,
Nicole?
that led me to have it like his question kind of. I was thinking like considering that the whole Bill of Rights and the Constitution was written like, so long ago, are there like hesitations with the Supreme Court on like following it so strictly?
Not the Supreme Court.
Not the Supreme Court. Okay.
No, I mean, it's absolutely a fair point. Our Constitution is more than 230 years old.
Yeah.
To what extent does it sort of outdate itself? Well, you're looking at my wallpaper and you see what's on my wall. You probably know where I sit on this. But lots of people have fair disagreements. And Nicole, I know you're patiently waiting.
Yeah, thank you.
Oh, I'm sorry.
No problem. I was wondering, I guess this obviously relates to this case, but just in a larger scale on your personal judicial philosophy, how do you reconcile the nexus or the kind of intersection between the 10th Amendment and other amendments in the Bill of Rights and looking at it in the scope of the rights of states to legislate being codified into law, but then when those intersect with other constitutionally protected powers, where do you look at that? What's the hierarchy for you?
So I have an hour to talk to you. Reed, I think that's like an entire comma class, right? Actually, I think I can't do this in a minute. What are you teaching them, Aaron? These kids are asking good questions. What books have you guys read about constitutional law? Maybe that might be a more interesting, because I can't do this in 1 minute. Oh my gosh.
She used the word nexus. By
the way, whatever Justice Scalia hated the word nexus. What book is that? I can't see it.
I have some Supreme Court like dictionaries, but I'm also reading Amar's book and Sandy Levinson's book. So we got some scholarship going on.
Reading Amar's book.
Did you read
Mr.
my
Hall
book?
gave our whole class copies of Amar's book.
Did you read my book?
Yes, we have that. Yeah.
We'll read that one next. We'll get a different perspective than Akil. Well, look, I can't possibly do justice to this one. What I could suggest, though, is that my common lectures are on YouTube the entire semester. They were both my former students, and they sat through it live, or I kind of live on Zoom. But if you really want to get a full deep dive, you can scan through my lectures, and that'll be a good thing. Also, Aaron has a copy of my book. That's a good place to start.
Well, and it's not a bad idea for him and Alex and Nicole and Arjun, if you're going to be arguing in front of judges like this, to know what their judicial philosophy is. And if one of them has recorded his judicial philosophy and it's free and live, for him, something, if you don't mind, something you asked, I'd like you to point you to a couple of sources. Prince v. US has a brilliant answer to your question where Souter and Stevens square off against Scalia, citing Federalist Papers, and they get into a back and forth. And basically they pulled the curtain back on their dialogues. Prince v. US was about chief law enforcement officers being able to enforce the Brady handgun instant background check. It had to be done by paper for about 11 months. And they went back and forth. And that argument spilled out into a lot of public lectures where they were very much in a collegial way, sniping back and forth at each other, to the point where Scalia started to say almost petulantly, stop waving the bloody shirt of Brown. Because the key argument from Souter and Stevens was, you cannot use 17th century or 18th century arguments and still have it apply, or otherwise we'd still have either human enslavement or segregation, which is why they went to that piece.
And it's like such an interesting, Yeah.
Yeah.
Yeah,
curious
definitely
about
I'll look into that
activism,
because
because
that was really interesting to me because it's like, if we did stop going so much off of that, then there would be like disorder. But then, so
but keep in mind that one person's
I-
activism is another person's
Yeah.
not activism. And in
Another
this
person's
case,
restraint, right?
yeah, Second Amendment, if they go here, this is conservative activism from one perspective. Roe would be liberal activism. An unbridled Second Amendment that ignores federalism is conservative activism from one framework. So that's not a legal argument. That's a judicial, philosophical, ideological argument.
I will need to bring the discussion to a close.
Yeah.
You guys can maybe talk later, exchange information. I think the email address is there. So we have another round coming in a few minutes and we need to
Yeah.
get the grades. But this was really a lot of fun. I can tell the four of you are quite passionate about this area. You have my email address, or at least Aaron can give you mine. Email me if you have any questions, but thank you. It means more to
Thank
me than
you.
it means to you. I know you don't believe me, but this is more valuable for me than it is for you. All right, everyone, take care. And if the judges can stick around, we'll carry for the next round.
Thank you.
Check your emails,
you.
Mike.
Thank you, Mr. Blackman.
Emails.
Thank you so much.
Yep.
Bye, Aaron. Wow.
That was crazy.
Yeah, reading a Mars book in high school.
It's an 800-page book.
No words.
Wow.
I didn't know who that was until law school, until like last year,
Like they have to go to law school. They're just like doing themselves a disservice.
basically.
Yeah. Holy cow.
That was crazy.
That
Yeah.
teacher's phenomenal. All the fact that he knows, I mean, like above and beyond anyone I ever had, for sure.
Yeah, no, Aaron, I've known Aaron now for one of his teams won the competition. He's been to the finals 2 or 3 times, and one of his teams won the competition. Yeah, so I mean I didn't pair them together deliberately. This time how the schedule just broke down, but wow, that was really
They were good.
I don't know how to grade them. All right, let's take a break at like 10 minutes and then we'll next round. We'll see what happens. Hello, welcome everyone. We'll be starting in a few moments. All right. Okay, so this is going to be match, excuse me, match number 5. Okay, we have petitioners. We have from New Hampshire, we have Leah. Are you here, Leah? Okay. Can you just say count to 5 so we can hear your voice, please?
1, 2, 3, 4, 5.
Perfect. Thank you so much. And also from New Hampshire, we have Elijah. Here, Elijah? You want to just count to 5, please?
1, 2, 3,
Good.
4.
Good. Okay. All right, good. Then we have from Oregon, we have the respondents. Flynn, are you here?
Yep.
Could you please count to 5?
1, 2, 3, 4, 5.
That's perfect. Thank you so much. And Serene, are you here?
Actually, it's Saren, and 1, 2, 3, 4, 5.
Saren, I'm sorry. Okay.
Yeah.
And how do you pronounce your last name?
Chin, like hair on my chinny chin chin kind of chin.
Okay, got it. Thanks so much. Okay, good. All right. All right. So I think, and Mr. Kepping, you're here? I think I saw you pop in somewhere in the back.
Indeed.
Okay, good. Thank you. Good to have you again. All right. So I think you all know the general format. The petitioners will have 10 minutes to begin. You will see a clock on the screen. It'll look something like this. Like that. You'll see the clock. Yes? Okay, good. When that clock hits 0, that means you stop talking, please. So you'll have 10 minutes for petitioners. Response will have 15 minutes. And then petitioner has 5 minutes for rebuttal. We usually give you about 2 minutes when you start off to get your opening remarks out, but it might be a minute and a half, might be a minute 40. It sort of depends whether there's a natural break. Then we'll start interrupting you. The more questions we're asking you, the better. That means we're following your arguments and we're curious. That doesn't mean you're doing a bad job. In fact, it's the opposite. That the more aggressive, the more hot the benches we say, the better you are able to respond. We'll ask you lots of questions. There'll be a lot of interruptions. When we start talking, you stop. It's very hard. I think it's even harder over Zoom. But once you hear a voice, you got to just stop it, which is a hard skill to have. When we go to the petitioner side, if the respondents can please turn off your cameras. And when we go to the respondent side, if petitioners just turn off your camera, that we don't have too many boxes on the screen. We have enough Zoom fatigue after 2 years. Do you have any questions before we get started? No? None? Okay, and also Ashley Wollaston and Reed Carrillo are 2 of our top students here at the law school. They're my former students, and I'm very glad that they volunteered to judge. They've both been involved with moot court and mock trial, and I think they'll give you some good questions. All right, let me start the recording.